So I think we'll get started. We might have a couple more trickling in, but it's great to, for our final seminar, we're going to have two speakers, Simon Davies and Julian Potter, who are both members of the National Institute of Patent Attorneys and very experienced in the field of software patents. So we're going to have a more legally oriented talk and then a practice oriented talk. So thanks very much.
Okay, good afternoon, good evening. We'll leap straight in. By the way, are you lawyers or computer people? Or a mixture? Sorry?
Lawyers.
Lawyers, okay. So, just being a patent attorney, you find that the engineers don't regard you as a real engineer anymore, and the lawyers don't regard you as a real lawyer, so you kind of like a bit of knowledge. Anyway, for those of you who don't know, there's European patent law is based on the European Patent Convention, which, unlike nearly all European things, is not a European treaty in the sense of the community, but is a separate standalone treaty. And Article 52.2 of that treaty defines certain things that aren't inventions. That's that list there: discoveries, scientific methods, etc. If it's not an invention, according to the treaty, or the convention, sorry, then you just can't get a patent for it because you can only get patents for inventions. And there's no positive definition of what an invention is, just that list of exclusions. And then they also put in that this subject matter of these things up here, which includes computer programs, is only excluded sort of as such. And whether that was intended to clarify, it's probably the least successful bit of clarifying that I've seen. So there is definitely a prohibition, and UK law, section 1 of our patent law, looks very much like Article 52 EPC. This is just to show you when the EPC was written, back in the 1970s. That's a computer, a microcomputer from slightly later. You may not be able to see, but there are a row of 8 switches along there, and you set each switch, and that sets a bit, and when you're then ready, you press enter, and that's like the equivalent to pressing one key on a computer today. So, not a sophisticated input. It was a long time ago. After the EPC came into operation, so the European Patent Office is the organisation set up by that convention which decides patent coverage. People were filing cases that were, involved software, and so it became very important to determine what was the scope of the exclusion, that computer program as such exclusion. And one of the key cases is Vicom, which is the T20884 is the reference number for the appeal cases, but it's a 1984 case. And it was a way of doing image processing. And it was, the way I've sort of kind of rationalised or explained it afterwards is, although it was partly to do with the mathematical algorithm objection, which was also listed before, there was a hardware implementation and a software implementation. And so you could argue that it wasn't a computer program as such. The invention wasn't a computer program. The invention was a technical process which could be implemented in hardware or it could be implemented in software. In other words, there's a difference between what the invention is and what the implementation is. And so the board basically said that this was a technical process. So the invention wasn't a piece of a computer program or even a mathematical method as such. It was a technical process of image processing which might be implemented by a computer, but that was okay. And since then, the EPO practice has been fairly favourable to what they see as technical inventions. And there have been a lot of those. Julian will give you some examples, I hope, of the sorts of things you can get through. But I mean, there are tens of thousands, if not hundreds of thousands of cases allowed by the EPO over the years, where software is a significant, if not dominant, element. And typically you can patent the control, using a computer to control external apparatus, or you can patent something that improves the operation of the computer in general terms. And so that's still the basic dividing line that the EPO allows, but we'll come on to some subtleties. One point for lawyers, there's statutory construction. The list of Article 52.2 is not supposed to be exclusive. So the EPO approach, which you may or may not be able to read, says that basically they have to generalise. It's not exhaustive. The phrase in particular means it's not exhaustive. Therefore, you might have to generalise it. In other words, so not just how do you generalise that list of things, discoveries, mathematical methods, computer programs, etc. You have to look for some common element, otherwise you've got no ability to generalise. And that's one of the justifications for their technical approach, that they see that technical is some form of a generalisation of that. So Vicon was in the mid-80s, and everything went fairly well till about 2000-ish, probably. And then there was the first dot-com bubble or whatever, and there were an awful lot of cases filed to do with implementing business methods, potentially business methods, over the internet. You know, you can think about companies like Amazon started at that time, PayPal started at that time, and so on. And people tried to get through patents for more business method type cases. So whereas Vicon was a method of image processing on a computer, which is quite scientific, quite engineering, quite technical, if you were looking at something like PayPal, that's much more of a business method being another one of those excluded areas. And the EPO developed this case law. Well, I should say, first of all, the US just decided that all that stuff was great, that was all patentable in the State Street decision. It said, State Street decision said there used to be a business method exclusion in the US, that's all wrong, we shouldn't have one, let's get rid of it. A judge made exclusion, they didn't get rid of a statutory exclusion. The EPO, for reasons that are fairly subtle, and I'm not sure I fully understand them, decided that the best way to deal with these sorts of cases was to say, okay, Article 52.2 or says that you can't get a computer program, but none of all these are on computer systems. Therefore, as long as it's as long as it's technical, as long as it involves a machine, it is technical. Okay. So they said that means that basically anything that PayPal or any of these companies put in involves a machine. Therefore, it is technical. Therefore, we're going to say it's fine for Article 52.2. They then said, however, that if, let's say, what you've really invented is a business method, let's say some way of, I don't know, I should be able to give an example because I see enough of these. Working out things like if you monitor your online sales, so you want watch what people are buying, and developing recommendations, which is quite a commercially very significant sort of thing. But most of the time, that's seen as quite business methody, based on what other people have purchased. So, although that's clearly implemented by a computer, they've said, okay, it's implemented by a computer, therefore it's okay by Article 52.2. But when we come on to inventive step, when we assess inventive step, we're only going to look at stuff that is technical, and using the if what you've done is clever because it's a business method, we're not going to say that's not going to be an invention. So I probably haven't explained that too well, but what they've sort of said is who is doing the clever bit? Is it the business person or is it the engineer? And for something like those examples, they'll say it's more the business person who is doing the clever bit. Therefore, the invention isn't part of we can't take those clever bits into account when we decide whether or not it's an invention. So this is something that confuses a lot of people, particularly outside Europe, because this approach is unique to Europe. In other words, some other countries have limitations on what sort of things could be patentable or could not, their equivalent of our Article 52. But very few of them then, people just don't go on to say, well, by the way, you can pass that, but we can still knock you out under Article 56 if your invention is kind of in the wrong area. And it is a little bit there is a bit of a pretense at the EPO because they say, oh, well, we still have this two-step process of Article 52.2, and if you get past that, i.e. if you have a computer involved, then we'll go on to Article 56. But I've never come across any example where something that is knocked out by Article 52 wouldn't be knocked out later by Article 56, if that makes sense. So what they've got, Article 52 becomes completely redundant because Article 56 is a narrower gate, so why have a wide gate when you've got a narrow gate later on? But anyway, that's what the law is. And I should emphasise, it didn't really change what you could get through in the end, it just changed the legal mechanism for what was rejected. The EPC was updated in the year 2000 to say that you can get patents in all fields of technology. It's generally seen as just confirming what I said about technical. So it wasn't expected to change the law much, and indeed hasn't changed the law much. And the EU proposed, remember that the EPC, European Patent Convention, is not an EU treaty. The EU proposed its own software directive, which was intended within the EU to harmonise and confirm the EPO approach. And this proved quite controversial, and in the end, it was the software directive was completely rejected. It was voted out by the Parliament, which is quite unusual for a directive. I think it was a second reading, and from Wikipedia, which is not entirely reliable, it's the only time that a directive has ever been voted out at the second reading. So it just died in 2005. And the reason that happened was that the directive was meant to confirm the EPO approach, what I just said about Article 56 and so on. And the people who were opposed to software patents thought we shouldn't do that. And so they put in a lot of amendments. And you'll be aware EU legislation goes through lots of processes, so there's lots of opportunities at council and so on to discuss amended texts. The people who kind of supported the EPO position got scared of the amendments, okay, because they could say this could make it much worse than what we're already living with. So, in the end, everyone, happy might be the wrong word, but everyone was okay with just rejecting the directive because the people who supported the current position said, well, actually, that's a de facto confirmation because if the directive gets binned, then the EPO is going to carry on doing what it's already done. And the people who kind of didn't like what the EPO was doing, at least didn't have it kind of enshrined in law. So it was a kind of semi-win situation. But, you know, that's where we are today. That's kind of nothing, well, there's one other thing that's sort of happened, which I'll come on to in a moment, hopefully. In the UK, so you can get a patent in the UK either by going to the EPO and getting a patent for all of Europe, of which we count as part of Europe, or you can just go to the UK office and they'll grant you a patent as well. You're not allowed to get both, you can choose either route. And patents, the UK Court of Appeal will adjudicate patents in two areas, on two occasions. Either a rejection from the UK office. So if the UK office refuse your patent application, you can appeal ultimately to the UK courts. Or if you sue someone for an infringement, then they can, or indeed any other reason, someone can go to the court and say, we think this patent is invalid, though that normally happens, and that may be a patent that was granted by the EPO. That typically happens during infringement litigation. So there are two ways that patents can get to the UK Court of Appeal, either through a rejection by the IPO or through a separate invalidation action. Now, Merrill Lynch it's a bank, as you're probably aware. I think it's still a bank. I don't know. Never quite sure whether it sort of went the same way as one of the other ones. And it was very business methody. And it's interesting that this date, 1988, the UK courts were having to deal with business methods a long time before it actually came to the EPO. And basically, the Merrill Lynch, they said, we like Vicom. I mean, in so many words, they said Vicom is a good way of telling what is allowable and what isn't. And then there was quite a long hiatus in UK law, and the decisions that came out were frankly rubbish. And then Airtel and Crossan 2006 was also back to the Court of Appeal, And they held that they were still bound by Merrill Lynch, so they were still bound by Viacom. So the one decision that I've taken you through is still effectively binding on the UK courts. So it is that, in theory, technical process. However, and McCrossan, as an example, the actual invention in McCrossan was a way of kind of preparing legal documents online. And that was very much held to be a business method. And the UK courts rejected it as a business method, not as the lack of invention. In other words, they still went for this subject matter thing. Just coming back to that point I made earlier about the construction of Article 52.2, UK court said there is no evident purpose lying behind the provisions as a group, a purpose to guide construction. One cannot form an overall approach to the categories. So whereas the EPO said we must have an overall approach, therefore we're going to have a technical process, UK courts have gone on record, and I don't think they realise they've done this. They've gone on record as saying something completely the opposite. They're saying that there is no general approach, and I'm not sure I don't think they quite realised what they were doing. But they did recognise that they weren't following that EPO approach of placing all the emphasis on Article 56 inventive step. And on that side, they basically said, we think the EPO's got it horribly wrong. They don't understand what they're doing. And they suggested some questions from the Enlarged Board of Appeal at the EPO. So whereas a court under European law might normally make a referral to the ECJ, because the EPC is not an EU treaty, actually the UK courts have no ability to make that sort of referral. The president of the EPO rejected that referral, said, well, we think basically the grounds for such a referral to be accepted is there must be some divergence in case law before the EPO Boards of Appeal. And the president said there isn't any. They've all gone this way. They've all gone from this emphasis on Article 52 to the Article 56. And if you do want to read, should you be so inclined, to read about the current EPO approach, that Dunn's licensing, that was where they basically said, they kind of answered the UK Court of Appeal and they said, you don't understand what you're doing, we do, and that's a decision which affirms the EPO approach. So, strangely enough, the EPO president, who then said there's no grounds for referral, retired or was moved on, and there was a UK president who decided to revisit the situation even though there was no new case law and said, there is a divergence, so I'm going to put it to the Enlarged Board of Appeal. And it wasn't the greatest referral, to be honest, when you read it. It was intellectually rather challenged. And the Enlarged Board of Appeal just said we're not going to accept it. They held it inadmissible because they basically reaffirmed what the former president has said. They said there's been a development of case law but not a divergence. So in other words, if you have contemporary cases which are going in opposite directions, that's a divergence. But if you have a case here which is in one direction and a case in the past which is down here, that's just a normal evolution of law. So, although technically it's inadmissible, so technically they didn't make a decision on it. If you read between the lines, they sort of make comments like, this approach has been adopted by umpteen boards of appeal and no one's had a problem with it. You get the impression if it had gone to them, they would have been quite happy with the approach adopted by the EPO had they chosen to take it. More recently, in the UK piece of law, we had the Hargreaves Review, which you may be aware of. This was mainly an IP and copyright-driven review, so I think it's one of the things you might be aware that is it like Cliff Richard Act or whatever, the extending term for musicians, impoverished musicians. That may have come out of this, I can't remember now, but there was a bit about patents, and certainly they collected lots of input about patents. And this to me was quite funny. They accepted that there was a divergence between the IPO and EPO, in part, IPO is a more difficult jurisdiction because they focus on the exclusions. So if it looks and smells like a computer program, the UK court, particularly the UK Patent Office, is more likely to reject it than the EPO is, despite the fact that ultimately they've both got the same law, okay? The UK law and the European law are supposed to be identical. But the practice or the approach isn't. Now, the Hargreaves Review accepted that there was this discrepancy, and they also accepted that in general terms, harmonisation is really good. So, this is something, I don't know if you could say it could only happen in the UK, but what their conclusion was, to rectify those two problems, was that the UK should seek to convince the European partners of the force of its case. So in other words, everyone else in Europe should align with the UK. So we've got it right, and that's the way we can maintain our position. I mean, you have to say that's grossly unrealistic, and I suspect that no one has actually ever tried to do this, but it happened, so yeah. But it's interesting because it is an official recognition that there is a discrepancy between the UK position and the EPO position. I've probably got about, not too much longer, I know, because just to be very quick, US Section 101, they have an exclusive law saying things like methods of manufacture and so on can be patented. Strange, if you're interested in the history of patent law, statute of monopolies, the US law is derived from that. You can still sort of see echoes of the UK law from 1620s in the current US law. And indeed, if you read the decision in Bilski, you'll see that they went through UK court decisions from the sort of 17th and 18th century to say, what is a business method? Could you patent it in the 18th century? It's quite interesting. But basically, the US is currently in a bit of a mess on this. State Street Bank, which I referred to earlier, came along and said you could patent all business methods. There was a case called Bilski, which basically, these are all kind of financial systems, aren't they? The ones that go computer and financial systems. Bilski went up to the US Supreme Court, which was split 5-4 on it. Although I think they all thought it shouldn't be patentable, but four of them thought that all business methods should be banned. 5 of them said that the US law says you can't, gives you some prior user rights if someone has patented a business method. So, which kind of suggests that in statute, the statute contemplates business method patents, and 5 of them found, which to me is an overwhelming argument in terms of statutory interpretation. But 4 of them thought that was not true, but 5 of them agreed with me. So they came close to rejecting all business methods, but they didn't, and they said basically they rejected it as being abstract. Bilski, that was the big test on that. Bilski was rejected for being abstract, which is in itself quite an abstract test for other courts to apply when you held something being abstract. And they also said that there was a machine or transformation test, which I don't understand, but they said that's not the be-all and end-all. There's no one overriding test. And you can tell they left a mess because it went back to their US Court of Appeal recently, which is another case, Alice Court. There were 10 judges who wrote 7 opinions, okay? That shows you how divergent that Court of Appeal, which is supposed to be unified. So it's gone back to the Supreme Court because I suspect the Supreme Court really did not want to take that case. On the other hand, what do? You're the Supreme Court, you're supposed to harmonise, the court below you is in disarray. You have to. So that will probably come out this year. Finally, just going to touch on open source and patents. Do you know what open source is? Some of you do, some of you don't. But it's Linux, Android, etc. It's software that is made available for free. Traditionally, the open source movement has been very anti-patents. So Richard Stallman, who wrote the license, covers Linux and Android. Any free program is threatened constantly by software patents, blah, blah, blah. Microsoft were very anti that, partly because they didn't like Linux. I think they probably go back a little bit from that quote. But certainly when the European Software Directive was being lobbied for, the open source movement were very antagonistic. and still are towards patents. This is a slide I prepared some time ago, so it's not completely up to date, but that shows the growth in software patents, which you can see it's quite a good business to be a patent attorney in software patents. You know, it's been a growth market. That shows the growth in open source over roughly the same period. And so, without being quantitative at all about it, there's this really nice positive correlation, which is not so easy to explain if you think that patents are really, really bad for open source. Because not only do you have a temporal correlation, but also if you think they have most patents in the US where the software industry is really strong, and you know that's where things are happening. So it is quite difficult to say that patents are really bad for software business. So conclusions. Those are the conclusions. I think I've said all that already. Alice Court may change something because they're the Supreme Court and they can change things. But certainly in Europe, I think it's been fairly steady for a little while. And I don't see the Hargreaves Review changing the European position. We won't change that. Thank you.
How do we say?
We'll keep rolling.
We'll do all the answers?
Yeah.
Okay, fine.
Yeah.
This is where I get challenged on my ability to use the technology that I patent. Oh, that's one. Yeah. Look at that. Marvellous. Right, a quick apology. I'm recovering from a cold. I may suddenly start to cough. Please excuse me. I'm okay now, really. It's just a hangover from a cold. So what I'm going to try and do is look at what industry actually does under this law, why it does it, and how we try and protect what our industry clients need to protect in order to protect their businesses. So, how does it affect business? How does this law affect business? What does industry, what does business want to protect? And actually, how do they go about protecting it? And I hold three things in my mind when I think about computer inventions. First thing is computers are ubiquitous nowadays, and therefore so are inventions involving computers. Because if computers are ubiquitous, therefore the inventions are. There's three basic types in my little world, anyway. There's computer implemented inventions that control the real world. So washing machine spin cycle, something that checks your toast is the right colour so it pops out. Maybe more importantly, if you like driving, automatic braking systems, those kind of things. There's the interaction with the real world. Very easy to patent. That's because there's something technical going on. To go back to Viacom, there's some kind of a technical process going on in that you produced a new image, a cleaner image, where you're making a brake pump very, very quickly so you don't lock the brakes up. That's technical. You can only really do that with a computer. In the old days, you used to try and tap your foot very quickly and usually unsuccessfully. Then the second type are improved computing apparatus, a more efficient architecture. Now just down the road from here, you've got a business been running for 20, 25 years that does that extremely well. They call it ARM. ARM, their whole business model is predicated upon IP. They don't make anything, but they design a lot of stuff, and it's very, very good stuff because the implementation of the processes and the cores that they design are in nearly every single smartphone in the world. Okay? But that is a new type of computer data processing architecture. Real things, very small real things on the silicon, but real things in a different arrangement doing something different. Again, you can start to, instinctively, you understand that that's technical. Or as I like to say to my clients, technological. Because technical in English language can also mean you have a technical financial instrument, for example, and that you can't patent. So I like to refer to things as technological. And then there's a third type of invention. the improved use of computing apparatus, how you use it, data processing, being able to mine data in a more effective manner, being able to visualize things in a more effective manner. Let's take relational databases. Pretty clever things, very useful. A little bit of searching before I prepared this little talk. 1978, UK patent to Bachman. Relational database, or an element of relational database. So pre-1978 was when the European Patent Convention came into force, 1st of June 1978. So in that very year, under the old UK Act, the 49 Act, patenting data processing apparatus that's implementing aspects of a relational database. That is about managing data. So we've been doing this stuff for a very, very long time. So what does industry want to patent? These are here, it's quite, some of you might be too young now actually to remember this, I feel I'm getting very old now, but in the mid-90s the UK telephone numbers changed from 10 digits to 11 digits. I was at Nokia at the time, and we had LCD displays, and you had 10 5x7 segment LCD displays that displayed digits on them. Telephone. When the numbers became 11, that was a bit of a pain because you either ran out of numbers, they'd run off and fall off the end of your display. What would you do? The solution that was proposed by a very smart chappie at Nokia was, well, every number begins with 0, 1. So we'll have a reduced width, 0 and 1. There you go. A thin 0 and just one line. So now we get 2 digits, and we always know what those digits are going to be. They're going to be 0 and 1 on the first segment, and then we can fit all the rest of the numbers in. Okay. How are you going to achieve that? How are you going to implement that on a telephone? Well, you're going to do it by maybe a computer program, I would have thought. But also you've got to remember that one of the other exclusions is the presentation of information. You can't patent that either. Well, what's that? It's the presentation of information. So how do you do, as a patent attorney tasked with the job that actually this is really, really good, it's going to solve all the problems with this new number, and we've got to get it in first, Julian. We want to protect this. How do you go about protecting it when you've got these, in my mind, the 2 major exclusions that we had to deal with? First of all, you make it look technical. This is the idea of not... it mustn't look like a business method or something abstract. Because as Simon said, it looks like a software panel or a business method, they're going to say it is. So there you go, there's your basic block diagram. Every Nokia mobile phone patent at one time started with that figure, it'll go figure 2. Okay, so processor, keypad, there's various telephone functions, transceiver, there's a radio telephone, there's a display driver and an LCD. Okay, it's technical, look at that, there's bits. Also, an honest guy, I decided to go through flowchart or a process flow control diagram. And this is so very useful because they tell you what's going on. Okay, so that's it, that's all described, all this stuff was described. But then you have to say, well, how am I going to define this invention? And when Simon was talking about the invention, what is the invention? What you have to remember is the invention is defined by the claim. You get a chance to define it, and this is what you're being tested against. Your claim is tested for novelty, an inventive step, and it's also what you test for infringement. But in this world of whether or not it's a computer program or business method, you're also testing that claim against that Section 52 test. Article 52 test. Is that claim claiming a business method? So what do we do? These are the weasel words. I'll put the number up, and the B means it's a granted patent. So you can check these things, that they do exist, I'm not making it up. So this is how, in this particular example, some 25 years ago, we said we have a display driver. Not a data processing apparatus, it's a display driver. Why does one say it's a display driver? it sounds technical. It's a display driver, right, real stuff. For a display comprising an array of n fixed character display regions. You were trying to give some kind of physical sense to the invention. Now, this isn't smoke and mirrors, and I totally agree with Robin Jacob when he said substance prevails over form when it comes to patents. You're not going to patent something that's unpatentable because of the form of claim. But sure as eggs is eggs, and Simon and I will see this all the time, particularly from overseas originating specifications, you can fail to get a patent for something because you failed to claim it properly. So here, n fixed character display regions, the driver comprising character generating means. Well, which bit do you think is the character generating means? It's the software. The character generating means, which in a first mode of operation, again, a first mode of operation, it sounds a bit technical. You know, and I like to think of software as levers and cogs, and try and think of it like that, and then write my claim with that kind of thing in mind. Which in the first mode of operation returns a single character to at least one of said display regions, and in a second mode of operation returns 2 characters. So what this was allowing you to do is where you still had the old 10-digit number, it worked normally, as it used to, and then when you had the 2-digit number, the 11-digit number, the second mode of operation would return 2 characters across the width of said at least one display region. Actually, the implementation, of course, it was that first one on the left-hand side. That's how you got the patent through for something that when you initially at first blush, you looked at it, particularly 25 years ago when I was a baby patent attorney, you go, how on earth do I get around the computer program exclusion and the presentation of information exclusion? And that I think most people get that. You understand how that works and why we should, I think, get a patent on that. Okay. Next thing, we're moving forward quite a few years now in 2000, internet boom. The problem here, we have an e-retailer. They were quite new things at the time, e-retailers. They have a catalogue of products, of books, say, that might be Amazon. Initially, they only have sales in US dollars. They implement their system using object-oriented programming principles. These are things, highly structured type of programming, which you create a certain class of thing, give it certain attributes, and then that creates a template. You can keep reusing that, and they appear in versions. Okay, that's a class version. So it has a class structure, and the first class structure they did was it was called book, and it had a title and a price in US dollars. A very simple object. Later, they wished to sell in GB pounds. Well, all of their data is in this first class, the US dollar type class. So if they want to now have stuff in GB pounds, under the object-oriented programming approach, they would have to duplicate everything to have it with pounds and dollars. Somebody with the original version of software would look at anything and just see dollars, know where it is. Someone with the updated version could get the one with pounds as well. Now, back in the day, and still is true to a certain extent, memory is quite expensive. I mean, and this isn't memory on your laptop. This is memory in a huge data warehouse somewhere that has to be run, cooled, and looked after. So what did they do? They didn't want to duplicate all this stuff. So what did they do? They decided that although they have everything in a class structure, and it must be in a class structure when somebody accesses it, what they're going to do is they're not going to store it that way. They're going to strip out all the class structure and store it in basically bit streams without any structure whatsoever other than basically bits. And then, depending upon which version you access the system with, it goes around and says, right, that's just a dollar version they're using, so I'll just go and get the title and the dollar amount for that and rebuild my object and send them with version 1 object. If it's a version 2 system that you're using, you'll get the pounds as well. The interesting thing about that is it's just data processing. It's taking the data, ripping it apart, putting it back together again in a particular way depending upon the type of request. Is that technical? Do you think that would pass the test? Is it a computer program as such? I think it's technical, that's because of my background. But I think a number of people, it's actually, that sounds to be very soft, because you're not making a machine, not making the outside world work in any different way. You're not making the machine a better machine, and it's using less memory, or it's using less power. You're just manipulating data. So that's the problem that you've got. There's a problem that might be viewed by the UK office as just data processing. So what do? We make the description technical. That's what we do. We go back to this process of I've got to draw out technological elements to you, the examiner, and you, the judge, to make sure that you really understand the technology that's going on here. And so you start with a computing platform, that little diagram at the top. Yeah, that's the basic elements of a computer. This is something real, judge. Okay? And then you describe the prior art problem, what the problem was. I just described the problem to you. Avoiding the mention of a business method. That is deadly. Yeah? I know it sounds trivial, but this is the thing about patents. I've said this for a long time, and it doesn't really matter what field you're in, but particularly in this field. Patents are works of written advocacy. The first person you're trying to convince is the patent office. But then it's your potential licensees, your competitors, to keep off your patch. And then maybe it might be a judge. Hopefully you don't have to get in front of a judge, but every now and then that happens. So you've got to think about this document as a document that's got to convince people of your position right from the get-go, right from the very start that you put pen to paper. So you describe the drawbacks in technical terms. Now, you might then contextualize them in a business method, but you've already got, hopefully, the examiner on your side. They understand it's technical, and this technology could be used, to sell books over the internet, maybe. Okay, but hopefully you've got them on your side about it being technical. And this gives a reference. This practical contextualization gives a reference to the technical advantage as well. It brings that out as well. They assist in focusing the claim on technological features which overcome the technical drawbacks. And that simple diagram at the bottom just sort of shows how the versions go in age, of earliest left, older to the right, and how they develop and what you're trying to do in the object space, or if we're really to computer science, the tuple space. But what this specification was trying to do was to take the examiner very carefully by the hand and lead them through all the technical arguments very, very simply, because you want them on your side. This is a diagram made it up with myself and the client. But they have the database, you have two bits of Werner and an evolver, and then your versions on these oval things, the different things that you may be, the different versions you may be using to access this evolver that then talks to this Werner. The guy called it Werner because there's a famous scientist, it's called Werner that he admired. That's the only reason why it's called that. But then does the stripping out into bits, or indeed retrieves the bits and starts falling into the right version to send back to the requesting client. Now, again, we're describing its hardware. We're describing the methods and the processes as steps of operating a piece of apparatus. Now, I've been accused of using smoke and mirrors by some very eminent lawyers when I've explained to them how to do this. It's not smoke and mirrors, it's understanding what the restrictions in the law are. It's about showing something that is technological and claiming that. So it's about making sure that you draw out the technological elements, even though it might be used in a business method, because you're not claiming a business method of selling books over the internet. What you're claiming is a method for configuring a data processing apparatus, for processing a first-class typed object in accordance with a first-class type version structure. having a class name. Now that is, I know about you, son, but I think that's very soft. I'm astounded I got away with that. But, and a second class typed object, which is right, and of course with a second class type version structure, having the same class name as the first one, and this was one of the problems, you had the same class name because you wanted to refer to them as the same thing. Configuring data processing happens with the first version class loader, yeah, you can work in the first version. Configuring it with a second one, because you're going to work in this other newer one. And then you provide a first class type version execution environment corresponding to the first. Yeah, so you can see, and I know Julie, feel free to print this out. You have a read through that claim, and you'll see how very, very soft it is. It's about playing around with data and creating execution environments of a particular type.
So what's the term type mean here?
Here, type, right. In object-oriented programming, the objects are a very particular type, and by that,
It means sort.
well, I define the type. So remember, the example I gave you was title and US dollar price. That's one type, book. Okay, you can then have another type of object that could be title, dollar price, pounds price. Okay, so they are different things. They're abstract things. They're bits of data structured in a certain way, and you say I'm going to have them of this type. They have similar characteristics, so they're the same type. But then also you can have different versions of that type as well, which are different generations, I suppose. And within object-oriented programming, the classical way is that you can normally go back in a version, but you can't go forward in versions. A bit like your Microsoft programs that are back compatible are very often not forward compatible. Whereas what this thing did was, we know there's this compatibility problem, we're going to strip out all of this structure, this versioning and typing, and just put it into basically a series of bits and keep it like that, and then rebuild it into the appropriate type when it's requested.
Okay, because sometimes it appears as type and sometimes as typed, and
That might
claims are never very straightforward to follow.
a second class type. No, well, the object is a typed object because of the second class type.
Right.
So the object is typed.
Meaning that
He's
it's
of that
subject to a process of kind of prior classification.
Yes,
already.
that's basically it's typed. It's made of that
Is
type.
it a class of fields?
Isn't
Is it a class of fields?
Not really in object-oriented, no. I mean, this is a particular branch of computer science, a particular way, structure of programming things, and certain computer languages are structured in this way, designed to assist you to structure in this way. But the key point is that this is very, very soft. You're saying you've got the data processing operators providing a certain type of execution environment to do certain types of software executions on data. But the way that this gets drafted is to try and draw out as much as possible those technological elements that are there. Because you can't get around the fact that it's manipulating data. You just can't get around it. That's what the invention is. You have to embrace that.
So can you explain why you think this mode of manipulating data is technical or technological? Converting bits of data into other bits of data. Can you just I know you're persuading the...
From a technical perspective, okay, there is a practical problem that if you and I were operating in different versions, our software had a different version for this thing, I could see some stuff that you wouldn't be able to see, and that's a problem, and it's a technical constraint on the systems. It's not because you can't read it; it's because your machine can't read it. So it must be a technical constraint. It's nothing to do with
But if I'm converting something from normal numerals into binary, because a machine can only read in binary and can't read in normal, traditional whatever the normal
Okay.
numbering system is.
Yeah.
Just because it enables the machine to work doesn't mean that that process of translating the numbers into binary constitutes a technical process. I mean, that's a classic non-technical process.
Or is it? Because it's using technical means, using a computer to do it. You are using the binary because that is a technical constraint, because computers work on bits, yes or no, on or off. That's a technical constraint. And this is one of the ways of looking at the business methods on the internet. Because when they first came out, a lot of people say, oh, you're just putting a business method on an internet. No, in many instances you were, but in a lot of instances you weren't. Because computers are remarkably stupid things. They will do exactly as they're told, but only do it that way or that way. Okay? And so what you found was actually you were redesigning the business process. Now, Hitachi has something to say about that in the auction, but you are re-engineering the business process so that it can work effectively on a computer, because computers work differently, they work in a very particular way, a very simple way actually, and very differently from the way that human beings work. So the business process can often have to be re-engineered, re-architected to work effectively on a computer. And that was another way, one of the tools that I use, the techniques I used, to try and identify the technological elements when clients were coming to me with business method patterns. We always came to me with a business method. You go, well, okay, yeah, I can't patent a business method. Let's see what else you've got. Let's see what technological elements are underlying your business method. You know, your business method, there's something, as one of my secretaries would say, what's the cool beans? What is the attractive elements of your business, the business method that brings people to your site? We find out what that is. Then I say, right, now, what are the clever technological things that make that happen, that everybody else has got to do if they're going to create that attractive force? And they'll try and patent that. Okay, so you're diving deep into the technical, into the technology. And it's got a B, it's got a B number.
I'm still some way from being decided by this one.
Well, I mean, you're right to be, because I give that without the B on it to my trainees, and they go, you can't get that, can you? That's not right. Here's the granted spec, have a read and see how you get it. So that probably represents...
So have you licensed that effectively, or people?
That particular thing, we got that done in a year. In fact, I know it was Dr. Gino Elbro was the examiner on this one, who's now policy and doesn't like computer power. I think I blame it on this actually. I got him to grant this, and he's not. We got it within a year, and the reason why we got it so quickly was because they were going through a funding round, and we got it through. And
What year was that? When was that?
Oh, 2000. 2001. So in the heat of the the internet boom.
It's one thing for it to be granted, and another for people to actually believe that it's enforceable.
Well, that's a good. It's a very good point. The fact that it's granted means you have an enforceable, prima facie enforceable right. That of itself should make you think twice if you see it. Certainly as a patent. If I was advising you as a business person, I'd say that's granted, that's a problem. Okay, if you infringe that, if they come looking for you. You may be invalid, fine, you can spend 100, 200, 300,000 pounds with me, I'll be happy to take your money and prove that it's invalid. But do you really want to take that on, or would you rather take a license for £10,000 or design your system around it? So you are absolutely right that just because something is granted, it doesn't mean it's enforceable, it's going to always be found valid. But it's a prima facie right, and therefore needs to be treated with some respect.
Yeah, so it's quite different from the situation where you find something far out, which the examiner didn't consider, because then you've got some additional evidence the examiner didn't look at, and you can say, well, we don't think this is valid because we've got some real reason why it's not valid. If all you're doing is taking a different position on how you interpret technical, then who's to say whether your position is right or whether the court's position is right? You're never going to get.
It's very fun. It depends on the judge.
Yes, you're never going to get a sort of definitive answer from from a lawyer, people go for advice on that sort of thing.
We look at Colin Burse now, and then was often in the Pax County Court, now in the High Court. He quite likes software. He gets it.
So can I ask you one more question?
Yeah, we're here for that.
I haven't even yet read it through completely, but one thing that concerns me about this is that your example is, you know, a book, your object is book price, and you've got it in that form and you want, what you've done is create a system that allows you to rip that apart in some way and put in the British price rather than the US price. The abstract form of this claim would allow it on its face to cover ripping apart any type of information in an object.
Yep.
So my question is, was there something new or inventive about ripping apart any object?
That's a good point.
That informed this?
Yes, and there was, because it breaks the whole methodology paradigm of object-oriented programming. You give this to a programmer, an object who's familiar with object-oriented programming, and he'll think you're mad because you're breaking all the design rules. Okay. You would never do that. Well, like, we have a problem.
So it does correspond to the contribution that the inventor has.
Yes, it does.
Made,
it does.
which was to a sort of paradigm shift.
Yeah, exactly. Yeah.
Objects.
Yeah.
Okay.
Yeah. Okay.
Maybe
So,
more persuading.
so okay. Yeah.
It sounds so different to what it started off with, which is this
Well,
particular business.
and that's how it comes to me, and to Simon as the patent attorney, as well, to try and turn it in. So you're right. One of the things that convinced me about this was the paradigm shift, because one of the things patent attorneys have to do is go, yeah, so what? We say that a lot. Convince me how clever it is, you know. So we tease out the clever bits, and it's during that process that I realised, or I was told, that nobody in their right mind, object-oriented programming, would do that. Okay, so
You now sound persuaded, but it could still be a paradigm shift in data manipulation.
It could be still a paradigm.
well, it is a paradigm shift.
I'm not yet convinced, but I was worried about just the practical side.
But the other thing is a method for configuring a data processing approach. So I was trying to constrain, it wasn't a method of, or method for doing something, it was constraining it for configuring, i.e. making a piece of data processing apparatus work in a certain way. So we're trying to make it machine-like. That's the specific machine point, I think, that had Bilski actually, if you put it into a machine, it's got to be okay. Now, another example, this is great. It's text-to-speech conversion, prosodic boundary markup. Prosodic boundaries give rise to intonation in speech, and you'll have very hard boundary markers such as commas and full stops and those kind of things. But also, prosody exists depending on the parts of speech. The tenses that you use is the inflection there is in your voice. And so this was basically one of the diagrams in this particular patent. You had plain text and news, and you went through and just you tokenized it, you characterized it, the words in some way. You tagged it with parts of speech, you identified what the parts of speech were, you had the whole grammar, English grammar. You then did some processing on it. You put where the prosodic breaks should be. You also then imported the punctuation breaks, the hard breaks. You then had something really, really clever, which said, also I'm going to look at the whole sentence, individual clauses of the sentence, and individual phrases and words to assist me in understanding how those should sound, so I can then start to put these prosodic boundaries in those as well to make it sound more human. And then, so I apply those constraints, then I have my text-to-speech synthesis at box 164. That's basically what's going on. So this is taking text and making it sound like a human being. Is that technical? By putting in prosodic boundary markers in the text itself, so when it's read out in a certain way. This is the claim. This, and it's a B, it got granted in the UK. And I didn't focus on UK ones initially because Simon, and quite rightly said, it's tougher in the UK than it is in Europe. But look what you can get, look, like I say, what you can get away with. Look what you can achieve if you know how to work within the constraints of the law. And automated, that's important. Okay, it's an auto, it's a machine, an automated prosodic boundary markup mechanism. The word mechanism makes it sound a bit more machine-like. Unless you have a German examiner who once told me he saw no mechanical arrangement in the drawings. So I stopped doing that for you. Anyway, an automated prosodic boundary markup mechanism for an automated. This is a machine, text-to-speech converter. The markup mechanism operable to perform a syntactic analysis on a text portion and to assign one or more prosodic boundaries to the text portion. That was all known. You can do that just by the punctuation. The markup mechanism, further operable, the fairy does, to apply a constraint, and this is new, don't know what that constraint is, it is defined in the spec, and it's actually defined in more detail in the subclaims. To apply a constraint to one or more prosodic boundaries, and to remove a prosodic boundary satisfying the constraint. And the reason for this removal of the prosodic boundary satisfying the constraint is this, is that if you solely rely upon the parts of speech, you end up with a very mechanical, robotic sounding voice. So you start to remove some. One of the key elements of this invention was actually removing some of these very hard ones based upon an understanding of what the text was. It then goes on to get this a bit more sophisticated later on. But that's, again, I think that's quite soft. When it comes to you, that's the alternative. It comes to you as a text-to-speech conversion that makes it sound like a human being. Okay. So that's claim one, is it? I don't think we're going to get that. What are we going to do? And then you dive into the technological implementation that they've got and tease out the clever technical bits that make it work.
If this had gone right through, what would the inventive step aspect be?
But did go right through.
Sorry? Yeah, so which
It's the applying the constraint. Because normally, the existing regime, what they would do was they just use the grammar, the punctuation, because that's clear prosodic boundary, and everyone understands what that is. What this did was actually take some of them out. Because if you just relied upon that, you ended up with a very mechanical sounding voice. So that was the clever bit. It was actually the realisation of why the voice sounded like that. It's fascinating. I learned quite a lot about language. So, other examples. So European. It's interesting. You're managing web services. It's right out there in the cloud. It's a service-oriented architecture. Okay, so rather than having things running on your machine, you go up and you use software services off the web as and when you need them. So you've got some kind of store which describes each of these web services that's registered in this store. You have filter. It filters a request for a service. And this is part C, is the clever bit. The service filter is adapted for gathering runtime information on what's happening as that service is running in accordance with the particular description in the registry. So this is a particular type of service, I know it is, and I'm going to monitor how it behaves in real time when it's running, because actually that's an important thing to do in certain types of business. Not least, has it locked up? Is it still running? Okay? That's patented by the European Patent Office. That's just running programs over the internet.
And what was the inventive step there?
Without going through the whole step, I believe it's C, where real. Actually, in patents, there's quite a big clue, and I'm not being trivialising it. It's the classic European way of doing it is characterised in that, and what comes after the characterised portion is the invention, or if you're more traditional UK or US draftsman, it's the wherein clause. So wherein the service filter gathers the runtime information about the request. What?
Aren't they supposed to focus on technical features in finding the inventive step?
Yeah.
That doesn't sound technical.
Why not?
Because it's adapted for gathering information.
How are you going to gather information in a computer without being technical?
Using a program.
But this is also running over the internet, so somehow you've got
The
to...
internet's been there for years, that's not inventive.
No, but somewhere in that whole process, you've got to decide where you're going to run this filter. Because the internet has been there for quite a long time. And the problem with the internet is everywhere. I mean, the actual physical backbone of the internet is you know, the campus universities, the campus computers here, the communications around my computer if I wanted to put it on there, etc. So somewhere you've got a service filter running at some kind of gateway, presumably for this service, the vision of these web services, that's monitoring the runtime behaviour, okay, of this service, which is important because it tells you what's going on with that service. So, for example, if you've got lots of these things running on, it's all automated, and one of them stops running, you as the service provider needs to know. You need to know very quickly. So it's a very simple example. It stops working. So you don't have to wait until people start phoning up saying, my software's not working. You already know and are working on a solution.
Do you recollect what the specific applications were?
Sorry?
Do you recollect what the
I don't. I didn't draft this one. This is me. I have quite a lot of fun putting in search terms and just finding as abstract as pragmatic things as I could.
That one in your original categorisation of the types of
A type of invention,
yeah.
This one, I think this one is a C still. It might be moving up towards the B. It's sort of making the system work better, but I think it's really a C.
So this could be something like a system of gambling websites, or a system of gambling services provided by a business. Do you think?
Yeah, it could be, yeah.
Where you have the registry where you've got all your different gambling services, and you can identify through your filter any client who is requesting one of those services at a given time.
Could be exceeding a credit limit, could be using it too quickly. There's been in the press now about these fixed odds machines, which have to give you time to pause and think about your next bet. So you could run it in there and control the way that somebody is betting. Make it run more slowly if you see them just punching away. Plural bet after bet, for example.
And the inventiveness lies in the service filter monitoring in runtime.
Yes. The information about that request in accordance with this description of that web service. So it knows what that web service is supposed to be doing, and it's checking it's doing, or checking something else is happening with it. Okay?
So you're really focusing on this word filter. It sounds something like concrete, but actually, in reality, it's not a widget, is it? It's some sort of programming
Depends
device.
how you view computer programs. As I said earlier, I view computer programs as a series of cogs and levers and switches, or indeed, I like to think of it as plumbing, with the data running through the pipes and stuff being operated on it. Because it allows me to draft claims like this.
That might be possible, except for the fact that the statute says that a computer program is effectively not technical.
It doesn't say so.
No, it says
It says it's excluded and it's separate. It says
But
patents in all fields of
if you
technology.
say what's the common overarching concept of all those, and you say, well, all these
But
things are not
listen,
technical.
The statute doesn't say that. So the
No,
statute says if you start with
implicitly.
computer programs and if you start with saying everything in technology is patentable, okay, then you would can say, well, ask people, is this technology? And most people would say it is technology. Yeah. So that's one of the problems that you have is if you start with the technology bit, which came from TRIPS. Yeah. So in theory, it doesn't have to tie into your.
I'm using it as a shorthand. I'm using it as a shorthand. Like, I know the statute too. But, like, didn't they, the EPO is trying to justify its approach, saying that we'll take a generous view of Article 52.2, but then we'll be stricter in Article 56, and we'll look for an inventive step in something, provided it doesn't fall, it's not within the
It's not
Article
excluded,
52
yeah.
exclusions.
Yeah.
So if they then say, oh, a filter, oh, that sounds like it's not obvious.
Well, it's what the filter is doing. I mean, the filter is adapted, which means it's configured to, I have a personal preference not to use the word adapted unless I'm generally adapting something. But that service filter is being defined and characterised in terms of its function is adapted for gathering this runtime information. Okay, so that is, it's not just that it's a service filter, and that is technical, that's what it is. It's what that service filter is doing. All of that is part of the technical element. But there's no question that the choice of vocabulary is important. Not because you're trying to get something back that you shouldn't, but you're wanting to draw out the technological elements of the invention. So the word service filter isn't the technical bit, it's service filter adapted for gathering runtime information about that. That's because it's doing something, it's monitoring signals and interpreting those signals and coming to some decision on the basis of that monitoring.
Can I ask a follow-up? So,
Yeah.
So why I want to push that particular issue is one question we've often faced in amongst ourselves is to try and get a grip on how different is the EPO from the UK? Because we say to ourselves, well, we can see, because we've looked at the case law in progress, we can see a difference between their tests in Article 52. However, the EPO also says, when it's describing its approach in Article 52, that nevertheless, when it comes to Article 56 considerations, it will necessarily require the non-obvious component to be in something that's not non-excluded.
That's not strictly true. What it says is that it can't contribute to the technical solution or the technical problem that is solved. So a computer program is an excluded item.
Yeah, okay.
But it can, so just going back to Vicom, which I don't know, but if a computer program is doing the image processing and producing a better image is the technical result, yeah, then the computer program, although the computer program is an excluded item, it is contributing to the result, therefore it is taken into consideration for the purposes of inventive step.
Okay. So you're saying that they won't strip out the computer program when they're looking at inventive step?
They won't go through, no, that's the kind of thing. They won't just strip it out. They'll look to see how it relates to the
They shouldn't strip it out.
Yeah.
Now, what the examining divisions actually do is a slightly different matter.
Right.
On appeal, they won't do it. But once a way of looking at saying you take everything out and a sunset is not quite true, because you are allowed to actually think about an excluded element or thing could be used to help you define the technical problems.
Mm-hmm. So do you come across situations, or do you envisage situations in your work where, let me just find a way to put this. So, supposing there's a application that is rejected on Article 52 grounds by the UK Patents Office. I know this is not really a practical situation because you probably wouldn't apply to both the IPO and the EPO, but in your head, But so supposing we've got a situation where if you put it forward to the IPO, we would think it would be knocked back on Article 52. However, we might think it might get through the EPO on Article 52 because they're a bit more generous. Would we always expect it to then be knocked out at the Article 56?
No,
that's a different review. That's a difference in process.
So you do find that.
And there was a particular case, Symbion, which went to the Court of Appeal. They did put it through both in UK and Europe, and the UK rejected it, and Europe didn't. And that decision got overturned, the UK one. But it does happen. People do put,
they certainly do try both if they've got the budget. But also, because there's two tests, inevitably you're going to end up with different results. You have to, because there's two tests. And not that, you've got different tribunals as well, and different traditions, legal traditions, so that complicates things.
And sorry, another test, does it mean that you're always going to win, more likely to win an EPO?
Well, you see, a lot of people say that, and Simon sort of indicated that he might think that one. I think that if I was asked to give a view, in most instances, I think you have a better chance of success at the EPO, in most instances. But because of the way that they apply this inventive step test, can sometimes have some really strange consequences.
It depends on the claim, how the claim's drafted.
Well, you see,
It's so much how it's it's a different approach to claim construction. The first one takes, the UK approach takes the claim as a whole.
Yeah.
And the EPO is supposedly eliminating some element that they don't.
Well, they are supposed to take the claim as a whole as well, actually.
Well, they say that's what they.
Yeah. I mean, there's a statement of appeal somewhere lurking in the EPO files where I caution against throwing the baby out with the bathwater, which is precisely that point. So I think that on the whole, you are going to get an easier ride in the EPO, but not all the time, and it's jolly difficult to know where the difference lies. But I think sometimes you might get something through in the UK that you don't get through in the EPO. So it's going to be unlikely, it's going to be rare, but I think that possibility exists. But as a general rule, if I was advising a client on the strategy, I could only go in one or other of the budget for one or other of the offices on the EPO, because that's the safest option.
Can I just ask a question?
Yeah.
Do you think if patents in other fields were subject to the same test of extracting out, eliminating the part that's,
Yeah.
you know,
non-technical.
Yeah.
Well, in that very statement of appeal in which I talked about cautioning you not about the barcode, I also said, and drew a parallel with pharmaceutical inventions, where in the pharmaceutical invention you discover something, it has some kind of medical effect, and then you patent the medical composition. You don't patent the effect per se. If you were to remove the non-patentable bit, which is a discovery, because you can't patent discoveries, and that was, as conflict says, that's sort of given over as part of the state of the art. Okay, everybody knows that. So then go to a pharmaceutical chemist and say, well, I know this, what are you going to do with it? They're going to make something that's going to cure people with it. So I argue that actually if you apply it to other fields, you'd end up with a patent, particularly pharma and bio. So I've described this as a sui generis approach to specific for software inventions, and therefore wrong as well. That's one of my statements. Just got to get a client to have enough money to go ahead and continue with it. But they're important points because it is it's discriminating technologies, and I don't know how to do that. I would submit.
So could you explain that point? Why do you think they discriminate between technologies?
Because if you were to apply the same EPO test to another field of technology, say for example biotech, where you discover a particular gene sequence and you discover what it's suitable for, what it does, because discoveries are things you can't patent. Okay, you can't take into account for inventive step. Well, the obvious thing to do with a gene sequence that has some kind of medical or therapeutic effect is to make some kind of medicament out of it. So the patent on the medicament would be obvious, because it's the obvious thing that you do once you know what the gene sequence is. Now, of course, you may do something clever in how you make that composition. There may be other technical things coming in that you have to do something smart to make that composition work.
Okay, but they've taken the same approach in that field as they're taking in computer technology. They've said you can't strip out the discovery in toto. You look at it.
You can't patent the discovery. You used in not biotech, but what I understood was you used to patent the discovery, didn't you? Yeah, I know this this is a gene sequence. I discovered a gene sequence, and then they said you've got to have utility, haven't you? And you've got to understand some kind of effect. I think that's a sort of test that you've got now. So I'm not. It's not my specialist area. It is very much a definite specialist area.
They would say that the DNA sequence is not only a discovery.
Well, that's how they get around it, because there's lots of work in finding what these DNA sequences are.
And because the EU directive says that if you've used a technical means to get to your DNA sequence, it's patentable.
But when you program a computer, you use a technical means to program the computer.
But you don't have a directive that says that explicitly.
Well, you don't. But that's an interesting point. You don't have a directive that says that explicitly. But that's why you're treating the technologies differently. If you have a directive in biotech that says that, and not an equivalent directive for software that says that, and if you were to not have the biotech directive, you'll have the same situation as you have with software, or you should have, and therefore you won't be able to get patents in the biotechnology field. Or you would have similar directive for software, in which case we would be, someone will be here, because it'd be much easier to get patents in software. So there are these distinctions, I think, that exist. And you go right back to one of the first slides that Simon showed, is why does this exclusion exist? It's something to do with public policy at the time. But bear in mind, in the 60s, in the 60s, there's some people going around saying there's only 3 or 4 supercomputers in the world ever. It's a really, really big, clever, and difficult things to deal with. They got that wrong. Anyway, I'm going to very quickly sum up now. I think it's a fascinating debate. Thank you for the contributions. I'm not going to go with that. I've got to go down. Oh, this is the fault. Actually, no, I'm going to talk about this one. A command setting device for use in a video game system of the type in which, I love this bit, a couple of teams. I don't think I've ever used a couple of things in any ever. I love it. This came out of Japan. I think there's a translation. Each having players. Basically, what it was, it's a football game. It's called Konami. Went to the Board of Appeal. It's a football game, and the problem was that the size of the screen, what you could see of the various players, meant players you might want to pass the ball to would be off the screen, off the visual area, if you could actually see what's actually happening. Or you'd end up having to have it diminished so much that you couldn't really see what was going on. So the clever thing, roughly saying, was you'd have a little marker at the edge of the screen telling you where your other players were. So you could pass the ball off the screen, as it were, and then it would automatically pan to that player when they got it. So it's like virtually enhanced the size of your screen, at least the interactivity of your screen. All about presentation information, isn't it? Great. But that was patented. And another one, ITS rugby, the blue squash ball case. Do you remember that one? Okay. That particular shade of blue, hue of blue, is easier to see on the squash court. That was the technical effect. It wasn't the presentation information. A very old case. So a lot of people get excited about these things all very, very new. Well, the case law's new. That's certain. And the value of these things are new. And what you can do with computers is extraordinary nowadays. And that's why it's big news. That's why people are looking into it, because it has it has major economic significance. Whereas back in the day, it wasn't that important. It didn't have any real economic significance. So I think that's why all this stuff is getting hot, because people are protecting their investments. And this leads me on to my last slide, which is the industry innovates in software. A lot of industry does that. Industry needs funding. Funding requires protection, and that requires patenting. There's a quite a long paper by Ronald Mann of Texas University of Texas. He looks at do patents assist financing the software industry? And he basically says yes. For SMEs it does, it's really important. And it stops aggregation towards the incumbents, because if you can't protect your IP, okay, you have no value, people aren't going to invest in you. What that means is that the incumbents, the larger corporations, through dint of their commercial power, their routes to market, etc., will dominate, and that will stifle innovation, because you don't innovate if you're a monopoly player. So actually what you've got is a lot of a highly fragmented software industry, as they can be. And you see the same thing in the bio industry, little biotechs. Lots of little biotechs are now, all of them patenting their own stuff, waiting for that breakthrough, at which point Glaxo comes in and buys them, or whatever. Okay. And the other thing, and this is really, really important, Europe has a reputation of being hostile to software patents. It does. You phone up the UK IPO help desk and ask and say, I've got an invention, a computer program invention, software invention, and they'll tell you can't patent it. What they should do is go and see Simon or Julian, or just go to CIPIL and ask for an expert, and they'll help you. Get this is generally hostile, but this is damaging, because it's up here. With some notable exceptions, many domestic European enterprises do not patent software in Europe. They do not patent their own stuff, and particularly SMEs, because patenting is quite a big investment for an SME. Okay. So they want to be sure that it gets it. The problem is that if you don't file in your domestic jurisdiction, you tend not to file in your foreign jurisdictions. In the US, for example, which is where you can get patents on software. So domestic European businesses don't get patents in Europe and they don't get patents elsewhere. However, foreign enterprises, notably US ones, do file for software patents in their home territory, and as night follows day, they will file for corresponding patents in foreign territories, therefore, say Europe, China, etc. And this puts European enterprises at a competitive disadvantage because they're not protecting their stuff at home or abroad, and yet their foreign competitors are protecting their innovations in their home territories and in Europe. Because it's a cultural thing. That when you look at the EPO, you look at the software panel, IPO is Simon's old employer. I mean, they created the early case law in the EPO because you get patents on software in the United States, and so we'll file from in Europe as well. Whereas European, I do think I can get patents in Europe, so I'm not filing anything. And so if you're not filing in Europe, you certainly aren't going to file in corresponding foreign, so you've got nothing to correspond to. So you don't file anywhere. More sophisticated sometimes, depending upon their advisors, but sometimes you have clients who will say that is so soft and so business method-y, we'll file in the United States because we're not going to get anything in Europe occasionally. That's quite a sophisticated client, but a reasonably sophisticated advisor. But most of the time, they don't patent in Europe, therefore they won't patent in foreign jurisdictions. But the other way around is, the United States particularly, US companies will patent in the United States, and they will go and then follow on patenting in Europe.
Yeah, but if you're suggesting that we should, that it therefore follows, like that might be a cultural fact. But if you're saying it therefore follows that we should expand what is protected in Europe, I think there's
I'm not necessarily saying that what that one should follow on from that. What I'm saying is it's a fact. What I am saying this is that we need to educate people in Europe as to what you can protect, because you have a lot of people, and politicians, and some very senior politicians, and even some people in patent offices will say you cannot patent software. I've been doing it for 25 years. Okay, and it really is, and it makes me quite angry, because it is that cultural thing that is damaging European enterprises, their competitiveness. And it's a tough world at the moment.
Well, there is a big literature on software patents in the United States that says that software patents are damaging US enterprises.
There is, and I've read a number of it, and there's also literature that says the opposite. And for a technology that is being damaged by software patents, where the number of software patents has increased dramatically over the last 20 years, and the use of software has increased, I don't see the damage. I don't see economically where it's hurting people. And you'll always see two sides. I mean, when some talked about
so the answer might be that the American software industry would be even bigger and stronger.
It might be
without software patents.
It might be, but Ronald Mann's thesis was that actually what you'll find is that the power in the industry will go to the large incumbents, and they'll be disincentivized to.
They have protection.
Not because they'll have protection, they have commercial protection. I'm a big guy, I've got lots of money, first to market, I can push my way around the marketplace, and all the little guys, well, just nick their inventions anyway, they're not there. And I'm not incentivized to innovate, because I've got the market sewn up, or me and a few pals have got the market sewn up. Whereas with strong protection, I can't push people around so much. There's more litigation by SMEs in the United States than there are major corporations. That's because major corporations tend to cross-license and tend to have I suppose you might call it a mature business relationship with each other. They have a cooperative relationship with each other on many, many things, including IP. Whereas the SMEs don't have that, they haven't developed those relationships. So you have to be really cautious, I think, just pointed out, I'm not saying the one follows the other. I'm saying it's a fact that you have that. What do you do about that? I like education. I like telling people what they can do because I do a lot of education, and I think that's important. What I do think is that we have to be software's funny, and the internet's a funny place because of all the technologies. There is I call it a subculture, and that sounds denigrating, it's not meant to be. It is a software people have a certain culture about them, and about the freedom of information and the belief that information must be free and you shouldn't control it, etc., etc. And that runs deep throughout the programming community and the software community. And it's important to look at Richard Stallman, for example. Just because they think that doesn't mean that should happen. Likewise, just because people think patents are a good thing doesn't mean you should run over patents. Both can coexist. Some put up that slide. Open source and software patents pretty much been working together. No problem.
I don't think arguing I'd say the patent system is perfect. You know, I mean, there are pros and cons, and it's not, you know, that's been true for, there was a lot of fuss when Alexander Graham Bell invented his telephone and stuff. So there are some pros and cons, but I also think that, you know, when I used to work for IBM, and you'd say, well, you get a patent on hardware and you get a patent on software, but you know, patents on software are more difficult or questionable. But from a business perspective, there's no real justification why you would have, you know, patenting in one area, in the hardware area, but not in the software area, because the commercial sort of situation that, you know, you pay, you invest. I mean, software programs can cost an awful lot of money to develop, to test, and so on. So that's the thing I think is worth remembering, is that, you know, really software is really just an extension of hardware and other developments and other product developments, and in that sense, it's quite logical to have a patent protection unless there are clear reasons not to.
Yeah, and I think that the exclusions on the methods of surgery, etc., you can see strong public policy reasons for that. I think this exclusion came in 1978, and there was legislation that was developed in the early 70s, late 60s, when we only thought there were going to be 3 or 4 computers. Actually, that legislation was out of date when it was written. It's massive, and in fact, I think the courts and the EPO have done remarkably well over all areas of technology, actually, to manage to adapt the law to biotech and other things, because there are things that are happening now that were never conceived of on that legislation. So I actually take my hat off to the judges, because I think that they've done really, really well to develop that.
This is, I mean, so I could accept what your policy argument. I might accept your policy argument that patents are a good thing for the software industry and that it ought to be available. Actually, I think the empirical evidence is uncertain, and we'll probably never have good empirical evidence for that. But let's just say we accept that. Okay, okay, patents are a good thing for software industry. What is happening really throws like the law into, like it makes you think it's just mocking legislation.
I don't think so.
And it's a good example of the common law going crazy and lack of transparency as to what's really going on.
I mean, well, there's an interesting, I was reading, occasionally I've gone back and looked at, you know, the Travaux Operatoire, not said very well for the EPC, but if you go back to a conference, there was a conference in something like 1970 when they were pretty well developed the law.
It's a media conference,
Yeah, I can't remember if it was that before, but I think it was like, and it was someone from not one of the governments actually said, well, we've got computer programs, but we think this is going to be overly restrictive on data processing systems. People aren't going to know what it meant, blah, blah, blah. And the chairman, and he says, you know, and all these things and systems, you know, because people, you know, people will still want to protect those. And what the chairman says back to him, I can't remember, it doesn't say, actually, those things weren't meant to be patentable. It says, we've thought about this, we've thought about how to get a different definition. It's all very, very difficult. We're just going to have to rely on the EPO to sort it out. And that's, you know, and I'm sure Julian and me don't defend the EPO that often because they get quite a few things wrong.
Yeah.
But in some areas, this is where I feel that they, I'm not even saying that they necessarily have taken the right approach, but they've taken an approach which I think is consistent and pragmatic, and also compared to the US has been much steadier in terms of what you can patent and what you can't patent than the US has managed to achieve. So I think, they were dealt a pretty bad hand in a sense from the law, and actually they've as I say, been quite consistent and not done too badly, and it's not their fault that the law is really a little bit, it is a problem for the reason Gina said about people not understanding it and getting confused, but the EPO can't really help that. What they can do is provide a consistent interpretation of the law, and I would challenge anyone to say to demonstrate that their interpretation of the law is definitely correct. I can see that other people might say, this interpretation, you could take this one, you could take this one. And the law doesn't really allow you to uniquely say one interpretation is correct. So I think the EPO, they've stuck with something and it worked. I think for industry it really worked.
It has worked, it's been practical. It's the use of words as such. They were put in there because they didn't know what else to do, frankly. And that's unhelpful. But within those constraints, I agree with Simon that I think they've done a pretty good job of giving us some guidance. I don't disagree with everything that they do, but I think they've given us some pretty good guidance. And all the examples I've put up, I am comfortable in, I'm a physicist by background. My initials JMP, I know are the mnemonic in 6502 motor and the microprocessor to go from one particular part of memory to another part of memory. I programmed in hex. So I go right back. So I understand. I built a PDP-8 computer at university. I understand more than, say, some more modern people, computer programs, how a computer actually works. I do believe that one of the problems we have, both in terms of patenting and also in terms of examining, is that some of the people doing the patenting now, and some of the people doing the examining, have been so used to working in high-level programming languages that they are used to ascribing sentience to computers, that they think. Computers don't think; they just do what they do because you've told them to do it. But if you're not careful, you can almost treat them as sentient beings. That's wrong, and that's why I like them. We go back to the technology platform and what's actually happening there. And I think that on the whole, everything I put up there, I think it has the necessary technological qualities that should support patentability, I think. And because they are things that require a lot of development work, a lot of testing, and they're part of the modern technological world, which is driven by computers now, unlike the 1960s, 1970s, which is quite a different place. There's shades of grey and where you draw the bright line. Could you draw the bright line? There's shades of grey and where you want it to be and where it should be. And I think that's open to debate. But I think that what, in my view, is unquestionable, have this holy trinity of technologies. It comes out of both laws of fire, or used to fire, and it has the holy trinity of fire. You have heat, you have fuel, and you have oxygen. Well, the holy trinity of technological advance, or at least economic and socially beneficial technical advance, is also a holy trinity there. And it's the heat of innovation, the fuel of technical resources. There's one other thing that you need, and that's the oxygen of funding. Because without that funding, that wonderful innovation will never see the light of day. Because it won't come to market, because nobody will invest in it, nobody will bring it to market. And that is why IP is important, generally, because it protects these innovations. And that's why in any field of technology, or even in any commercial field, and you might think that business should be patentable, that's debatable, but commercial endeavours need to have some protection around those endeavours to ensure that they can attract the funding necessary to breathe life into those commercial endeavours, because without that funding, it's going nowhere.
Okay. So you see patents actually as operating as incentives to mechanisms for commercialisation?
Yeah, not as incentives to invent. I think I think it's rubbish. I don't think there is. Nobody invents to get a patent. Well, there's a few people. They normally walk into office with a big brown bag under there and ask you to sign an NDA. it's usually run on sunflower oil and it's anti-gravity or something like that. But very few people invent to get patents. Or the incentive,
Well,
in my
I
view,
mean,
is
in pharma,
investment.
So in pharma, you'd say there's a lot of money put into R&D to create the inventions.
Was to create the product. Yeah, to create, yes, but
So
that money
the
is...
ex-ante story
Mm.
that patents incentivise activity before invention works at least to some extent in pharma.
Okay. It does, because you know that the patent exists and you will get the funding.
Yeah.
Yeah, so yes, the ex-ante, it does work, but it's not that it's the fact that the patent will assist you in obtaining funding, not that the patent promotes the research and development. It's what the patent is capable, or possibly might provide you with. Because if you have a patent on something that doesn't work, and you can get patents on things that don't work, it doesn't matter that you have a patent, you're not going to get funding. Yeah.
I think there's a difference, but I don't.
No, I'm interested.
I don't want to pursue it really.
Yeah.
So the question is whether the existence of a potential patent in the future for your invention incentivises activity before the patent is granted, or the patent is granted to incentivise activity after the patent.
Oh, I think it's the former.
Oh, you think it's the former?
No, I do.
Because you started off by suggesting it was the latter,
Okay.
and I thought that was very interesting.
No, I think it's.
And it has a pedigree in some law and economics literature as well. So.
I think it's the former, but I think it's the former not because it's because of what the patent or the IP, another source of IP, provides you with, which is the opportunity for funding. That's.
I think it's the latter in biotech.
Sorry?
I think it's the latter in biotech. Oh, sorry, in pharma.
Well, I mean, when it comes to clinical trials, it's the latter.
It's the latter,
okay.
yeah.
But when it comes to the R&D that goes in before, isn't it the former? I mean, that's the traditional model.
Can you really separate them out?
Well, that's.
I mean,
Well, no,
I think that's what
I'm
you're trying to
interested in
say.
clinical trial
What's the
as
point
well.
of
I
having
think
a
that's
patent?
an interesting point. Sorry, mate.
I'm interested. Do you see what scope do you see then for the computer programs exception?
I think it's going to remain pretty much as it is.
Sorry, when would you see? When would you see it actually? When do you see it actually function?
When the shutters come down. When the shutters come
Yeah.
down. Right. Well, the shutters come down when you have a. Well, let's take the example, the marketing data example that you were giving earlier. There's quite a lot of those around. The shutters will come down when all you were doing is looking at people's behaviours and totting it up to aggregate a behaviour in a certain region or a certain time of day. And if there's nothing technically clever going on in the way the data is collected, there's some kind of technological problem with collecting the data or some way of analysing it, or any one of those things that I'm going to put up there, you're going to go nowhere. And that's when the shutters come in my experience.
So just like a new application, data mining.
I think data mining might be, but the EPO, when they were doing EPC 2000, the EPO's proposal was to get rid of all those categories. Yeah? So we're just going to say technical, so get a patent, any good technology, that's what they wanted. And they were kind of talked out of it. Particularly, I think the UK office said they wanted to keep the exclusions because they were very attached to the exclusions. But the EPO policy is almost like, that was what they wanted to do because they get rid of all the exclusions because we don't use them. And in a sense, they've just carried on doing that. So their use is fairly lightweight. I think the one area where you would they might be if you said, okay, I've done something else, almost like an aesthetic iteration or a business method would be the most important one, but it must be technical because it's on a computer, which is a machine. Then they would come back and say, oh well, okay, just because it's a computer program doesn't mean that it's technical. If it's a business method, the fact that you've done it on the computer isn't going to save you. Actually, it is going to save you under Article 52, but they kind of carry them over into the non-technical bits of Article 56, so that's how they use it.
Well, there's a logical problem with the application of Article 52, and there still is in 1.2 in the UK, because when you had the contribution effect, what you actually used to find was at the search stage, the examiner would say, I'm not going to search this because it's excluded subject matter, which I'll go back and say, well, how do you know that? Because the test is for a contribution. You don't know what the contribution is until you do the search, do you? And they used to do, actually frequently used to do the search for me. So there was so actually I quite like the EPO's approach. It's more logical in that if it is a computer program as such, there's nothing else there, then you fail at that first hurdle and your job will ought to. In my view, it's totally abstract. It's a piece of music, let's say. Okay? Then so move to Article 56, well, the business method. If all this is a new business, is a business method, existing business method, running on a computer, what it will say is, and the business method is non-technical, because it is non-technical. And all you've got is a general purpose computer, and they're well known. And if you were to say to a coder, code that, they'll just go, well, they'll code it, because there's nothing clever going on. They're just taking general purpose computer and coding it to perform business method. And I think that's more, I think it's more logical than this idea that you used to have, which is, it's not making a technical contribution to the sum of human knowledge. So you're not even going to search it. And so how do you know what the sum of human knowledge is until you perform your search? And there used to be, in my view, logical lacuna that still exists to a certain extent in the UK. So I'm reasonably comfortable with the EPO's approach. The law I'm reasonably comfortable with, the practical implementation of it sometimes gives me concern from time to time, but as something to work with, I think is reasonably practical, and we can understand it, and we can explain it to clients, importantly, and business can understand it and know where they stand, which is, I think, one of the important things about the law generally, when it impinges on your business behaviours.
Do you both think that there's been quite a lot more convergence between the UK and the EPO since Aerotel, and now in light of recent cases, well, in Aerotel it was quite dismissive of this concept of technicality, but these days more emphasis is put on step 4 under Aerotel.
I think one of the differences I find is that you can get quite misled by looking at the case law, because you have what's applied at the UK office, and there's quite a big gap to what the Court of Appeals say. And I find the UK, I think the courts are actually possibly more favourable to them than you will get at the UK office.
Yeah.
But the reason nowadays, because the EPO generally seems more favourable, like the only people who apply to the UK office by and large are small companies who can't afford to appeal anyway. So I think Aerotel was particularly positive. I think Colin Burr seems more, comfortable, because in the past some people have just not understood these things anyway and been frightened by them, and judges all like them. But if you see them in the correct context, they're quite, and hopefully of course it used to its mobile phone litigation, then they will actually understand there's nothing really very special about software patents, it's just another version of hardware patent, it's very closely sort of part of the same family. But I don't really think that in practical terms the UK has become closer to the EPO, because in practice, at least until I stopped filing them about 3 or 4 years ago, the GB panel was really quite negative, and then I do very little better now. I suspect it might be coming back a step.
It is coming back. I think it's Burs's decision. I think it's the second Halliburton case, where he was around and Nicholas Humphrey was in the first Halliburton case I was involved in.
Sorry, I missed that. Which case?
It's the second Halliburton case. In the first one, which I was involved with, I actually found myself arguing against the claim. It's not a patent, it's excluded subject matter. And there...
This is drill bits.
Drill bits, that's the one, yeah. And there, Nicholas was really quite uncomfortable with the fact that we were arguing that something was excluded when the end result of that was a damn great drill. We had them in the courtroom. And you could see that he didn't like that very much. Now, as it was, that was fatal for a number of reasons. Not least, there was a mental act in the claim, but also the patents weren't actually sufficient in their entirety, according to the judgment, so they went down on that. But he was quite concerned. And there's an interesting piece of case law which is in the design of a VLSI circuit, an IBM case, I think, where the original design, the claims for the design process, and the EPA said, you can't have that. And so they put in an extra step of making a circuit to that design. And that actually is pretty naff. You're quite right. I mean, I looked down and thought, oh, really? I don't like that, because I think that is getting to form over substance. But Nicholas was also quite concerned about this idea that you had this, on his face was very clever design, methodologies, automated design, so you could test these things and how they might behave 5 miles underground in earth formations. And yet not, because in essence the way the claim was drafted, not get protection for it. And when Colin looked at the second hand announcement case, he looked at the end result was a piece of hardware, and that was one of the, as far as I recall the case, was one of the contributing factors to it being found patentable. But part of it, I think, goes back to making sure that when you draft the claim, you define the invention, you do so in the technological terms, and make sure that you do properly define it, because if you don't properly define it in technological terms, then you shouldn't get a patent for it, because you're not defining a technological invention. If you do define it in technological terms, you've got a better chance, and if it's novel and inventive, then you should have a patent on it. But you have to have, of course, the technological features there in the first instance, and the invention there in the first instance to do that. But I think both Simon and I think agree that we've seen stuff which, had it been in our hands from the get-go, we would have got a patent on it, but it wasn't. And therefore, I mean, Amazon one-click, I think, is a great example of, I do wish I'd had that to draft. And it's the way you approach things.
I mean, I'm sure this can go on forever, but I would like to ask you one more question about one of your slides, which was the one about the the gambling thing that I was, or where I was trying to work out what it might actually cover. What worries me about a claim like this is, imagine that I'm the first person who's providing a web service who thinks I'd better just monitor what's going on. And so I create some monitoring device. I mean, don't you think that that monopoly is just much too huge for the contribution of creating a monitoring device? I mean, I can't. Once you've had the idea of monitoring whether your system is working.
That's not a specific objection to software patents, though. That's just a general thing as to the scope of the claim.
The thing is that in software patents, it is argued by many commentators that the claims are very abstract and cover an inordinate breadth compared to the claims.
I think it was true that in the sort of maybe the 1990s, particularly the US early 1990s, I remember when I went to the USPTO and they were doing their searches from cardboard boxes, because US, they got their patent classifications, and they were very used to examiners just flipping through the cardboard boxes and paper things and looking for pictures that match. And that's great in the mechanical side of things, but it's really not very effective in computing. And also the classification scheme, because it's a new technology, wasn't very effective. So I think the searches weren't very effective, and a lot of the examiners didn't really know what they were doing. I don't think the EPO is always, this wasn't where it's always done a lot of keyword search, and EPO searching has been much better, and I don't think now that software patents are necessarily any worse or any better than other fields.
So you don't worry about this one here?
But I can't tell.
It's difficult to know what it is.
Yeah, I mean, you need to read the whole specification.
Yeah.
But I think one of your points, I think, is an important point, is the nature of software is it's so flexible.
Yeah.
That you can do so much with it that it almost doesn't seem like it's a proper invention sometimes. You can get real breadth without doing an awful lot. And that I think is a very valid point. This also is a weakness of the software patent as well, because you are required to disclose something sufficiently completely for it to be put into practice by a skilled person, or ordinary skilled person. So if you make it too broad, you could run into a sufficiency problem. And that is the way I think you should tackle overly broad claims.
Okay, except that you only have to, because they're product style, as long as they're product style claims, the person skilled in the art only needs to be able to have one way of achieving that claim, post-Lundbeck.
That's true.
If it's a class of products,
if you like the court of appeal in Lundbeck, that's not what the Supreme Court.
Now, what this is interesting.
Well, they didn't seem really to address that point, did they?
They
because it was a single. They interpreted it as a single product claim,
Sure,
so they only dealt with that issue. But
you can.
so we don't really know, I suppose, what the Supreme Court's view is. We have a class of products. Because this might be interpreted as a class of products.
Yeah, and I get what you're saying totally, because it's the nature of software. But then it's a weakness. And your interesting point about Lombard is interesting because that's not always applied in practice.
Okay.
I know research is in the field of shell shakers for oil industry. Basically, you get the mud gets pumped up, it's put in a big basket, and you rattle it, and you try and keep the right sized lumps of clay because they can be reused, and they're useful. And also the fluid is also reused, and it's managed for environmental reasons. And this was very interesting. You had something that had 3 layers, and you could have with various flaps and valves. You could manipulate where the stuff was going to go to decide what size of particle you wanted to retain. One of the series of the embodiments had a weir. So the fluid would go over the weir. But the claim said controllably switchable. And I said, hang on, the weir is not controllably switchable. The weir is just a. And so in that instance, and I must admit I was flying a kite at this point at our hearing, because I knew very well that at least one of or at least part of the claim was probably supported by the description. I said, well, you've got to cut out all those embodiments because they don't properly, or the claim, so far as a switchably controllable weir is concerned, is not properly supported by the description because it doesn't tell you how to do it, because it's just a regular weir. Now in that instance, and it is going on appeal, but in that instance, the opposition defence said, yes, cut out all those embodiments. So, and I think they were right to do that, because that was technically difficult to do. How do you get a switchable weir? Because weirs by their nature aren't switchable. The switchable weirs, they're valves. So I think it depends upon the circumstances, and it might go down to this idea of class of product. I think you're talking about that. There are 2 classes. There's the switchable sort of valves and flaps, and then there's the weir, a different class of product, and that certainly wasn't switchable, and they hadn't taught how to make that switchable. So that might be where that distinction lies.
So how would the class test work on this? If we imagine this is a class.
Well, just because there's more than one embodiment under it.
Then you would have to show.
Whereas in Lundberg it was a particular left-hand version of a molecule. It doesn't get much more discrete.
I think that's very difficult though when you start taking case law and tests that are applied in one very specific area and trying to apply them to this. It's one of the things that the patent system is a bit compromised across all technologies. And people have tried to do stuff that's very specific, create new IP schemes, if you like, that are very specific. But no one really, that just adds another level of complexity sometimes, things like integrated products, circuits. So it's good to have something that is generic because it makes it easier for people, because you can be consistent, but it does mean then you have to twist it a bit at the edges to get everything to fit.
Okay, so if an examiner said to you, on something like this, it's show me that a person skilled in the art can perform this across the breadth of the clay.
They can't say that to you because they have to raise an objection that it's not sufficient.
Right.
It's not, the onus isn't on you to prove that you can do it.
Well, that'll come with some reason why there'll be some the opposition might be easier to raise argument, because I'll have my technical expert telling me why that covers things that aren't properly supported or aren't taught in the description.
It is very difficult though in software to raise these insufficiency arguments, because for legal terms you only have to get it to work. Now you might want something that it may work very slowly. In practical terms, this may be quite difficult. In practical terms, this may not be really commercially feasible, but as long as you can do it technically, so it may slow your website down too much that no one actually does it this way. But it's still patentable, it's still an invention. But in a sense, that's not bad. It doesn't matter, because if it's commercially not feasible, even though you've got a patent on it, it doesn't actually affect what they do.
It will stop other people, because they're not going to want to
It may
spend
stop something you have a really good commercially feasible.
No, what I'm saying is
They wouldn't do it.
But it won't.
Yeah.
But you're saying then it does cover something that is technically feasible. What I'm saying is if it covers something that is not.
No, but the point. But if the scope is as broad as that, and it's proved in some way, people are going to want to work around. and
Yeah.
take out.
Yeah,
But the thing is,
I-
Julia, I think that the thing is, what I'm saying is, if this, in its, of course, its full scope, slows your website down so much, people aren't going to do this, they're going to do something else. So therefore, it is economically benign. It has no effect because everybody's going to do it. So the fact that it's broad scope doesn't matter. Now, if on the other hand you say that certain ways of implementing this aren't good, but there may well be ways of implementing it so it does look very unfortunate in that. And that's wrong, because there people will be stopped. I still think you have a sufficiency argument there. I still think you have a wrong one, in that, but my point would be that it covers, the claim covers certain implementations and embodiments that are not taught by the description and cannot be done, therefore it is deficient in those. It's a bit like a bio-gym type argument. But I think that's important, because this idea of, as long as I teach you, no matter how poorly, to do at least something other than is not the right test. It can't be right. That sounds wrong to me.
So does that argument get run practically?
One of my favourite squeezes is the sufficiency inventive test squeeze at the position division, and it's really, really effective.
Yeah.
Really effective.
That's in opposition.
That's in opposition proceeding, it's not at the EPO.
Not at the EPO.
So that is not at the examining division, it's at opposition. And I think some of these things are actually quite complicated, and you wouldn't really expect the first level of administrative tribunal, the examining division, to deal with these. They are fairly course-filled, and they do a very good job for that. But really, it's the sort of thing that needs to be thrashed out between opposing parties, I think.
So at the examining division, Simon was saying, essentially the examining division would have to say, it doesn't work in this example.
It's normally when you have something that is contradictory in the application itself, you know, or it says, you know, you've got something that some inconsistency, and you've got something plain, and so a description clearly produces something different, it doesn't have that step.
Yeah.
Or possibly there's some prior art they found which says it's very difficult, but they normally have to have something either in the application itself, something external to say why it didn't work.
Yeah.
It's unusual, but you know,
It's very unusual first instance.
if you've done that, you've normally made the best of the application.
Yeah, you're pretty.
Or you've inherited one that someone else.
As I say, I can't remember actually doing one of my own cases, but I do know that if I came across a sufficiency case or one of my own cases I drafted, I would be very upset, be very disappointed in myself, because I would have felt to have done that a good job. So it's quite rare.
It's always going to be in an opposition, so that's...
I think so. It's,
Somebody pops up and says, hang on a minute.
Yeah,
we want to do this, and
we want to do this, but also we have expert evidence. We've got somebody who can submit some expert evidence as why that doesn't work, or why it's not proper, why there's difficulty in implementing it on the teaching of the specification.
So
that's
Strangely enough, I've got a board of appeal case next month, which is almost try an inverse of what you're doing, which is it is a database case, and they have raised the broadest request they've said is obvious, inherently obvious to the skilled person over the prior art. So they've got one document. I mean, it's an Oracle case, and they've got an Oracle manual as a prior art. They said it would be obvious to change the product to do this. And then there's a more detailed claim, version of the claim, which they've said lacks sufficiency, which is just the main way of doing it. It's like, you know, the patent describes the main way of doing it, so we put in more details about the steps. But it's almost trying to do the reverse of what you're doing, which is to say, well, you know, how can you say on one hand the skilled person doesn't have to do these steps of implementation, whereas you've actually said it would be obvious for them to do it. There's like an inconsistency.
There's an inconsistency.
Which I'll be interested to see what they make of it. But yeah, it's, you know, that was quite a lot of relational database.
But the thing about where we started with this was that's too broad, and I think all what we're discussing is the nature of the technology itself, and especially it's very, very broad, and I think that is a weakness in the weakness in patent, but equally in the way that the examiners approach it. I think they should be more robust in the teaching that is being provided for some of these very broad claims. Much like bio, they used to do that in biotech. They've toughened up on that. I think they could do the same in software appropriately.
So just to make sure I have a handle on what you're saying, your favourite argument is inventive steps, efficiency squeeze, so just
How's that run?
play out?
Well, it's really simple because all markets have to be simple. Basically, it's like this. It's they haven't described this sufficiently well enough for the ordinary person to put it into effect. Okay? Because they say it's really clever. If it's that clever, you fail to describe it. But if you're saying, actually, the skilled person would know how to do X, Y, and Z, well, their knowledge is so high, and that's clearly obvious. I mean, it's a little bit more sophisticated as one puts it out, and one sort of supplements all of that with examples, of course. But that's basically how it works. And it's wonderfully, wonderfully powerful, because most European patent terms will come in very, very hard on it's really, really clever, and it's really difficult, and it's really clever. So they're already setting the bar really, really high as far as the description is concerned. So then you come in with, what is that clever? Then you haven't taught this.
Because they tend not to put a lot of description in. Is that why it works so
They
well?
tend not to think strategically when it comes to. See, I'm a litigator, so I tend to think like a trial.
Yeah.
So I think right the way through. So my opposition is all about strategy. And I don't. Most European appellatives don't do that.
They've held a lot back to keep it in trade secret.
Yeah, well, they may have held stuff back, or they just don't think how they're going to plead or argue the case. They just don't argue the case very well. They just focus on it's really, really clever because that's what you say if you want it to be inventive, isn't it?
Yeah.
Well, yes, it is what you say. You've got to be really careful because this is other thing lurking in the background that could come back and bite you if you're not careful and get the balance right. So it's a very simple argument, but a very powerful one. And in the EPO, you would plead those directly going on your notice of opposition because you have to set all the grounds out in your notice of opposition. You can put them in later with the permission of the other side, like you're going to get that. If you miss it out, you miss it out. So you make sure every single ground is in there, even if it's a flaky reason, just to get it in. Whereas in the UK, in the court, for example, you'd actually tend to bring that out as a trial point in evidence. From the experts, you do it in a different way. You wouldn't plead it quite so overtly as you would in the panels, because the rules are different.
So when you said that how you would draft the claims to make sure that you get past the Article 52 requirements, are there particular things that you do when drafting for sufficiency purposes?
Oh yeah, I probably over-describe.
Right. And that's the
I probably over-describe because what I'm trying to do is I'm trying to say the civil line is so stupid. I'm having to describe how all this works. Okay. Yeah. I don't want to run the risk of somebody saying to me, "You haven't said how you do that." So I tend to over-describe. So assume that the skilled person doesn't know very much at all. Build up. And other traditions, even in Europe, Germany's one, Finland's definitely one. They will assume the knowledge of the skilled person is quite high. And a lot of the time, as a Nokia, we were rewriting specs in the priority year to augment the technical description quite significantly, because they assumed a very high level of knowledge. So it's all good fun. But that's a bit gone a little bit away from software. Strategy and so on. I hope you've a lot of it. I hope
we can keep talking.
Well, it's been fascinating, wasn't it? I really enjoyed it. That was fantastic. So thank you so much.